Hello, and welcome back to Coin Lady channel. After Coinbase chief legal officer, Paul Grohl, made a comment, XRP's lawyer refrained from accusing SEC of not fighting for their rights. Printer Pro X in response to Grohl's worries on the SEC's second mention of investment contracts in reference to currencies, attorney John Deaton has harshly criticized the U.S. Securities and Exchange Commission. While he acknowledged that the term investments does not automatically imply an investment contract, he stressed that such a document would be incomplete without a promise to share in the company's future earnings or assets. He went on to say that just because something is called an investment does not mean that someone is an investor. In the Supreme Court case of Edwards, this viewpoint is in line with the stance adopted by the Securities and Exchange Commission. According to John Deaton's response and critique of the SEC's approach, investment contracts are seen as having debt-like equity participation. John, a former federal prosecutor and well-known as an amicus curiae in the Ripple v. SEC a case, expressed his displeasure with the sexist behavior. He outlined a thorough criticism of the actions done by the SEC in reaction to the post that was published on X. Deaton stresses the gravity of the position and the honor of representing the United States in his memoirs about his career as a prosecutor. From my experience as a former federal prosecutor, I can confirm that federal government solicitors in the U.S. are expected to consistently wear the white hat. Standing up and saying "I represent the United States" in an open court should be enough to make anyone shiver, as Deaton pointed out. He made a comparison to the methods used by the SEC and the DOJ on their websites during that time. Reading about XRP from a Wall Street financial industry veteran shows how much potential it has. The XRP supporting attorney continued by outlining the role that federal prosecutors should play in upholding the rule of law and the pursuit of justice. Although a competitive spirit and a desire to win are typical, federal prosecutors are expected to be regulated by the legislation on the notion of justice, according to Deaton's. This is true whether they are pursuing civil or criminal matters. He conceded that the pursuit of justice and compliance with the law should be the source of these sentiments. Speaking it before was an honor, and it served as another evidence of the basic differences between solicitors representing public companies and those representing private companies like Ripple or Coinbase. In addition to public prosecutors, according to Deaton, the Department of Justice and the Securities and Exchange Commission's commission have disregarded the privilege and honor that their clients represent. Federal prosecutors, he was told, should be led by the rule of law and the concept of justice, as opposed to private solicitors who must look out just for their clients' interests. According to the XRP supporting lawyer, federal prosecutors are required to adhere to the rule of law in their pursuit of justice, whether they are handling civil or criminal matters. Claiming that a lawsuit against XRP shows dishonesty and inconsistency ought to be their central point, he continued. See which Judge Net Byrne exposed in the Ripple case, and Deaton also focuses on the SEC's purported hypocrisy and inconsistencies. Citing Net Byrne as his source, he argued that SEC lawyers like Georgia Tenrero and Gerber Gruhl are more concerned with winning arguments and promoting their agenda than they are with faithfully adhering to the law. Den asserts that the Ripple scenario is just one of many where this issue arises. On the contrary, it is a common thread in many various types of legal disputes, including those concerning grayscale. Deaton, an XRP supporter and Voyager bankruptcy and debt bot reader, discusses his feelings on Warren's invitation to run for the Senate. This criticism has its roots in the opinions of debt Deaton's and has been echoed by appellate and district court judges in a number of instances, including Ripple Grayscale, Invalidate Your Bankruptcy, and Debt Box. The situation has deteriorated to the point where a federal judge may impose sanctions on SEC lawyers for debt, pointing out that they have forgotten their duty to represent the United States with dignity and honor while upholding the principle of justice. Lastly, his speech demands accountability from the SEC, suggesting that Gary Gensler and then SEC Enforcement Director Ten be fired. Coinbase has several interesting names on its docket, including the fact that its next court date is January 17, 2024, when it will file its request for judgment and continue its legal battle against the Securities and Exchange Commission. This follows Coinbase's rejection of the SEC's regulation request pertaining to cryptocurrencies on December 15, 2023. Coinbase consequently filed a request for judicial review on December 18, 2023. At the moment, XRP is trading at 5 cents per coin. Ripple's shocking new information regarding Ripple's XRP supply dropped by chief technologist. In a series of recent tweets, Ripple's chief technology officer David Schwartz disclosed an astonishing fact about the company's XRP holdings. XRP in escrow lockups is subject to a ledger, and CRP is already available in Ripple wallets. The other category of XRP is not accessible to Ripple until escrow releases it on a monthly basis. We tried several different strategies, including sales with lockups and using XRP as an incentive for partners, but the vast majority of the released XRP has already been returned to escrow. We also discovered that all the things that worked were functionally similar to selling XRP. February 8, 2024, in reaction to a Ripple-related tweet from former user Mr. Huber, XRP distribution highlights the opportunities that Ripple has in relation to its XRP holdings. It can either keep its current level of XRP holdings or reduce them. There is no other choice available, was his subsequent statement. It was originally intended for Ripple to rapidly reduce its holdings of XRP, as pointed out by Schwartz. He continued by saying that he can't think of a chain reaction that would make this first idea even slightly plausible. People that are pessimistic about the event believe that it may not bring substantial benefits even if it does happen. Once XRP reached a market price, Schwartz said, people would spend money to gain the freebies, so they had to halt them. The original plan, he said, was to use giveaways largely to reduce the quantity of XRP that was available. In addition, Ripple explored a variety of other options, such as lockup sales and the use of XRP incentive for partners. For the first time, it was discovered that everything that worked was basically the same as selling XRP. If you believe Schwartz, the Ripple has been around for almost a decade and is over halfway through its 5-year plan to address user concerns about things like escrow and supply burning. While the deal was being finalized, as a result of his doubts regarding the escrow's merits, Schwartz admitted that he could not make up his mind. The chief technologist of Ripple's also expressed disapproval of the idea of removing escrow supplies, suggesting that this approach might not be effective. Please subscribe, share, and leave an X if you enjoyed this. See you later, bye.